got to give me content, you've got to give me written curriculum, because otherwise this right that you've now given me in the Human Rights Code of my province is meaningless. And so that's what happens when you put it in the code. So then suddenly we create chaos. Alternatively, they can turn around and say, you've given me this right, but in my exercising this right, my child has to now sit in the hall playing with his DS or something like that. And in effect, my child is being discriminated against now, because it is not, I cannot crystallize or act upon my right that is in the code without otherwise adversely impacting my child by making him or her sit in the hall. And so therefore, you've breached my right, and so you need to actually come up with a whole new way to teach my child during the time that that education is going on. And all of these things, this is not trying to create a panic. This is not trying to blow it up beyond what it is. It's not. This is the kind of thing that happens when you put a new right into the Human Rights Code. And let's just be clear, this is a new right that we are putting into the Human Rights Code. There is no other Human Rights Code in the country that has this right embedded in the code. It is embedded elsewhere, not in the Human Rights Code. But this is the kind of chaos that we will create. So we will become, so then of course the other thing is that under the School Act it is not necessarily the case that the teacher would become the subject, a respondent in a Human Rights Commission hearing. The teacher would not necessarily become compelled to defend their course of study, defend the way in which the particular issue came up in the class. They wouldn't under the School Act. They will now. Another consequence of putting it into the school, into the Human Rights Code. So, again, for the member opposite, this is not a symbolic change. This is a substantive change, and it is a change that is going to significantly limit the way teachers approach their job in the classroom. And I have numerous friends who are high school teachers, who are high school social studies teachers, who are high school English teachers, who are high school science teachers. And the teaching moment is a critical way in which they engage their students in critical debate in order to bring about a truly meaningful education. And that process will be limited by this substantive provision, which is now, for the first time in the history of this country, proposed as a human rights provision. So, in short, what we are going to do is we are going to not just protect the rights of that one child to have certain things kept away from them in the school setting, but we are also, while we do it, we are setting up a system that for every other child whose parent does want them to get a balanced education, to hear both sides of every story, to engage in a thoughtful debate, those parents' children's rights will ultimately be impeded because of the natural chilling effect that will arise from this being an element of the Human Rights Code. So I don't have a lot of time left yet, so I want to go on to the issue of where I think we are, in effect, creating a second tier, a second-class set of human rights in our Human Rights Code. And once again, I believe we are leading the way in the country in our efforts to create a set of second-class human rights. Without this Act being in place, thanks to the Supreme Court of Canada, gay and lesbian Albertans enjoy the same protection under the Canadian Charter of Rights and Freedoms as gay and lesbian people across the rest of the country. That's because, as we all know, the Supreme Court of Canada insists that the right to protection from discrimination on the basis of sexual orientation is in effect read into our code. And of course, we were hoping to actually have it written into the code to create a symbolic victory. Unfortunately now, what we're doing is we are now saying we're going to write it in there, but then we're going to treat it just a little bit differently. So in our Human Rights Code, we say people cannot be discriminated against on the basis of their race, on the basis of their color, on the basis of their gender. These are a long list of prohibited grounds. We are now about to add sexual orientation in writing to that prohibited list of prohibited grounds. And of course, as we know, it's already been read in there by the courts, but we're going to actually put it in writing. Yay, us. But then, through Section 11, we're going to treat that prohibited ground differently than all the other prohibited grounds, because some people think that parents need to have the right to recognize the personal and sensitive core beliefs that they need to massage and parent their kids with. So, apparently, we as parents need to be able to shelter our children from one of the prohibited grounds in the Human Rights Code of this province. We're not giving parents the opportunity to exclude their children from instruction on other races. We are not giving parents the legal opportunity to exclude their children from instruction on other cultures. We are not giving parents the legal opportunity to exclude their children from instruction on other genders. But we are going to give parents the legal opportunity to exclude their children from discussion about sexual orientation. So what that says to me is that we are treating it differently. And so while the Supreme Court of Canada had told us we couldn't treat it differently, now we are going to say we are treating it differently. And that is why I am so offended by this piece of legislation. Because after 11 years of ignoring the Supreme Court of Canada's direction that we write in that sexual orientation is a prohibited ground for discrimination, we're going to write it in and then we're going to qualify it, and we're going to treat them differently than other minorities within the province. And to me, that is deeply, deeply disturbing. And I think we should be very, very embarrassed. Now, at the end of the day, you know, there's been lots of talk about, oh, well, the School Act already allows them to do that. Well, as I say, the School Act talks about religious and patriotic instruction. And the school policy talks about sexuality. But this is not about sexuality. This is about some people are disabled, some people are brown, some people are women, some people are gay. That's all it is. And our children should learn that they should all be treated equally. And our schools should not, under any circumstances, refrain from telling our kids that, all kids that. Because if it's in our Human Rights Code, presumably we believe it too. So that is where we are left with all of this. And as I have said, it is very, very concerning to me that we are embarking upon a path to, first of all, limit the breadth of discussion and intellectual curiosity within our schools through a mechanism that will put a chilling effect on our teachers, and then at the same time create a second tier of human rights in the province.
You have